Okay, good afternoon, everyone. Can everyone hear me?
Yes, Sean, I can hear you.
Okay. First of all, I would like to thank all of you for allocating your time on your Friday afternoon to participate in this webinar. My name is Shaun, and I'm a senior associate in the Dispute Resolution Department of Rosli Dahlan Saravana Partnership. I am a construction disputes lawyer, so I'm quite familiar with arbitration because it is the main mode of dispute resolution in construction disputes. I'm honored to be given the opportunity to kick off the RDS Academy's continuing legal education webinar series. And I'll be kicking off today with my topic, Key Principles in Arbitration. It'll be mainly focused on international arbitration rather than domestic arbitration, as these principles are more relevant in the international arbitration setting. I understand that most of the participants today are young lawyers and students, and this webinar is targeted for people such as yourselves. The objective of the webinar is to introduce you to the key principles of arbitration, providing a solid base on which you can build your knowledge. It's not meant to be a comprehensive webinar on arbitration. I hope that at the end of the session, you'll be familiar with the key principles in arbitration, and you'll be able to apply these principles to your legal research, legal analysis, and in drafting an arbitration agreement if you're a lawyer. And for students, I hope this would assist your understanding of arbitration and the arbitration process for the purposes of your alternative dispute resolution studies. Without further ado, let's start with the session. Let me just give you a bird's eye view of the session today. A general outline of the topics that I'll be covering are listed on the current slide, and this would include what is arbitration, the definition, the key elements of an arbitration agreement, and then we'll zoom in on those important elements such as the seat of arbitration or place of arbitration, the importance of it, the considerations when choosing a seat, the consequences of choosing a seat, the substantive law or governing law or law of the contract, the arbitration rules, the types of arbitration, whether it's institutional or ad hoc arbitration, local or international arbitration, how is it categorized, choosing the number of arbitrators, and a brief overview of the arbitration process. So let's begin by looking at what is arbitration. As everyone is aware, the default or primary method to resolve a dispute is by going to court. Alternative dispute resolution refers to any means of settling disputes outside of the court. Arbitration is a form of alternative dispute resolution and perhaps the most popular one. It is essentially a consensual method of dispute resolution that involves a neutral third party making a final determination which is binding on parties to a dispute. It is a consensual method because it requires parties' agreement to resolve the dispute by arbitration. If one party does not agree to go to arbitration and there's no arbitration agreement, then the dispute cannot be resolved by arbitration and parties will need to go to court. The arbitration agreement is also important because it confers jurisdiction to the arbitrator. So with that in mind, what should an arbitration agreement contain? There are certain key elements which it should contain. The first would be a submission of a defined scope of disputes, either any and all of the disputes arising out of a particular contract, or only a limited scope of disputes. Typically, for convenience, parties would submit any and all disputes arising out of a particular contract to arbitration. If this is not done, parties may need to go to court to decide the disputes which fall outside the scope of the arbitration agreement, and this would defeat the purpose of the arbitration agreement or arbitration clause. So secondly, what should be contained in an agreement? An arbitration agreement would be where the seat or place of arbitration is. I will elaborate on what the seat or place of arbitration is later on. This is not the venue in which the arbitration is held. I think just for your understanding at this juncture, it should be noted that it is a juridical seat, which has legal consequences. It is not just a venue, and I'll elaborate on this further as we go on. The arbitration agreement should also state whether the arbitration is institutional or an ad hoc arbitration. It is an institutional arbitration if it is administered by an arbitral institution like the Asian International Arbitration Center, which is also known as the AIAC. An ad hoc arbitration is conducted pursuant to rules agreed by parties themselves or laid down by the arbitral tribunal. And again, I will elaborate on this further later on in my presentation. The arbitration agreement should also contain the rules of arbitration to govern the procedures within the arbitration, how the arbitrators are appointed, and so on. And it should also state the number of arbitrators, and this is usually a sole arbitrator or a panel of 3. The language of the arbitration, typically it's English, and then the venue for proceedings to be held. There are also optional elements which can be included into an arbitration agreement. You'll be prudent to include it, but not including these optional elements will not be detrimental to the arbitration process. One of the most common additions would be an arbitrator's qualifications. Parties can include that as part of their arbitration agreement. For an example, if a contract is a maritime contract, parties may wish to specify that the arbitrator should have at least 10 years of experience in the maritime industry, because his specialist knowledge of the industry would assist him in resolving the maritime dispute and understanding the issues involved. Okay, another additional optional element would be parties can agree to additional guidelines or rules. One of the more common ones would be the IBA guidelines on taking of evidence in international arbitration. Parties typically include this in their arbitration agreements, as arbitrators are not bound by the strict rules of evidence. They have the discretion in assessing evidence. So what the IBA guidelines do is they provide more certainty to parties in terms of how the evidence is assessed and weighed. Parties could also include a precondition to arbitration, making it a multi-tiered dispute resolution clause. Typically, parties would agree to have good faith negotiations or mediation first before proceeding to arbitration. This would help to resolve disputes expeditiously, or at the very least narrow the scope of dispute which goes to arbitration. And with that, that covers all the key elements of an arbitration agreement. The AIAC has a model arbitration clause, and it is on the current slide. As you can see, it is a submission of any dispute to arbitration in accordance with the AIAC Arbitration Rules. And they recommend that parties include the seat of arbitration, the language to be used in proceedings, the governing law of the contract, and a precondition to arbitration. The model clause, as you can see, it's fairly simple with clear language mandatory and clear language, and it's how arbitration agreements and clauses should be drafted. Now let's look at another key principle in arbitration. As I mentioned earlier, the substantive law, or it's also known as the governing law or law of the contract. The substantive law is usually specified in a separate clause in the contract, but sometimes it is also put in the dispute resolution clause or arbitration agreement. Why is it important? It essentially governs the legal relationship between the parties and the merits of a dispute. So it's basically which law would apply when interpreting provisions of the contract. For an example, if a party alleges that there is an implied term in a contract, the governing law of the contract will be applied in deciding whether there was an implied term. This to me is quite essential, and not specifying this in your contract will lead to issues which may obstruct the whole arbitration process. The arbitrators may then need to decide on this issue, and it will just delay the whole process. Moving on to place or seat of arbitration. It is basically the home for arbitration, and it determines the law governing the relationship between the arbitral tribunal and the courts, and it determines which court has supervisory jurisdiction over the arbitration. Just to elaborate more on that, the place of arbitration is a term used by the UNCITRAL model law and arbitration rules. And UNCITRAL is actually short form for the United Nations Commission on International Trade Law. It is essentially the golden standard for arbitration law and arbitration rules. In fact, the Malaysian Arbitration Act is based on the UNCITRAL model law on international arbitration. And the AIAC arbitration rules incorporates the UNCITRAL arbitration rules. So the term place of arbitration is used interchangeably with the seat of arbitration, and it means essentially the same thing. Okay, the definition section of the Arbitration Act says that a seat means the place where the arbitration is based as determined in accordance with Section 22. And Section 22 states that parties are free to agree on a seat of arbitration, and failing such agreement, the seat shall be determined by the tribunal, the arbitral tribunal, having regard to the circumstances of the case, including the convenience of the parties. And notwithstanding subsections 1 and 2, the arbitral tribunal may, unless otherwise agreed by parties, meet at any place it considers appropriate for consultation among its members, for hearing of witnesses, experts, other parties, or for inspection of goods, other properties, or documents. This shows that the Arbitration Act draws a distinction between the seat of the arbitration and the venue in which it is held. It is different, and I think people often confuse these two, and they think it's the same thing. Yeah. So why is selecting the seat so important? It determines what procedural law applies and where to go for relief. Procedural law here means the law governing the relationship between the arbitration and the courts. And in other words, which Arbitration Act would apply to the arbitration. And it determines any recourse by parties during the arbitral proceeding or after an award is rendered. So what does this mean? the procedures to apply in the conduct of an arbitration, for example, is something like Section 6 of the Arbitration Act, which is basically the receipt of written communications, and it specifies how communications should be received. This is distinct from the arbitration rules, which provide for the procedure within the arbitration, like the appointment of an arbitrator. And the consequence of selecting the seat will also be the level of court assistance or intervention. For an example, the Malaysian Arbitration Act at Section 8, it says that no court shall intervene except where provided by the Act, so that there will be very minimal intervention or obstruction by the court during the arbitral process. And the seat also determines the applicable law to challenge the award. So there are certain grounds which an award can be set aside, and it differs according to the law of the seat. Typically, it's basically public policy, or there are other grounds of natural justice and so on. So what should you consider in selecting a seat of arbitration? The place should be a party to the New York Convention. And what is the New York Convention? It is essentially a treaty signed by over 160 countries. And the signatories agree to enforce an arbitration award made in another signatory's country. This facilitates the process of recovering monies from various jurisdictions. So you should certainly select a country which is a signatory to the New York Convention. There must also be favorable laws at the seat when you select it. What does this mean? For example, minimal interference by the court in arbitration proceedings, so that the proceedings can be completed without any hindrance. It should contain a provision like Section 8 of the Arbitration Act, as I mentioned earlier, where it limits the court intervention unless provided specifically by the Act, which is basically setting aside, and for interim measures. Another factor that should be considered is whether a foreign lawyer can appear as counsel. This is important because parties may want to use the lawyer from their own country because of familiarity. Certain countries, they do not allow foreign lawyers to appear as counsel, even in arbitration. Another factor to consider when choosing a seat is the availability of interim relief in aid of arbitration. Most countries would allow an arbitrator to provide interim relief, and this is important. For example, if the respondent is disposing his assets during the arbitration, if the arbitrator is unable to freeze the respondent's assets, the respondent may be left without assets at the end of the arbitration, and the award may not be beneficial to the claimant. Okay. And public policy is also another consideration because it is a ground to set aside an arbitration award in most countries. Parties should consider if the particular contract is against the public policy of the seat, and if so, it is likely that that award cannot be enforced there, and the court will not provide assistance during the arbitration. To provide an example, if the contract is regarding the sale of marijuana, for example, which is legal in Holland, but it is illegal in Malaysia. If the seat of arbitration is in Malaysia, the Malaysian courts may refuse the enforcement of the award here on the basis that it is against public policy. Okay. Moving on to the arbitration rules, which is basically a set of procedural rules applicable to the arbitration process, upon which parties may agree for the conduct of arbitral proceedings. It is common for parties to use the arbitration rules of arbitral institutions, because this will also mean that the arbitration will be administered by that arbitral institution. And this would help them with administrative matters and will help to will help to expedite the process and prevent any hiccups throughout the arbitration process. Alternatively, if parties choose their own set of procedures, the arbitration will be considered an ad hoc arbitration, and it will not be administered by any arbitral institution, but rather by the arbitrator himself or by the panel of arbitrators. So what are the pros and cons of an international arbitration? Sorry, an institutional arbitration and an ad hoc arbitration. The advantage of institutional arbitration is that there is an automatic incorporation of a set of recognized arbitration rules, and the arbitration institution would help with the administrative matters during an arbitration, like the collection of arbitrators' fees, the booking of hearing facilities, and so on. Some of the more popular arbitral institutions are listed on the slide. They are the ICC, the International Chamber of Commerce, the AIAC, Asian International Arbitration Center, the Singapore International Arbitration Center, SIAC, and so on. There are also international institutions which have arbitration rules that provide a procedural framework for arbitration of investment disputes involving a country or a country's entity. For example, the International Center for Settlement of Investment Disputes, ICSID, and the Permanent Court of Arbitration, the PCA. On the other hand, for an ad hoc arbitration, it is conducted pursuant to the rules agreed by parties or determined by the arbitral tribunal. The advantage of this is, of course, flexibility, in that parties can shape it to meet their needs and their wishes and the facts of the particular dispute. But the disadvantage of this is that there will be no administrative support from any institutions, and the parties may actually struggle to agree on a set of rules, which would obstruct the arbitration process. One of the common pitfalls in an ad hoc arbitration would be the usage of institutional rules without the institution. It is quite common, but it is not advisable to do so, because the institutional rules may not work without the institution. As an example of this, Rule 12 of the AIC arbitration rules, it requires a technical review of the arbitration award by the director of the AIAC before it is issued to parties. If the arbitration is not administered by the AIC, then this step is not possible. Okay. Yeah, and it will not work. So why institutional arbitration? The arbitration institution would provide administrative support during the arbitration, like supervising the conduct of the arbitration, acting as an appointing authority if parties are unable to agree on an arbitrator, or the procedure to appoint a panel of 3 arbitrators. The recognition of an award will be more straightforward, because you will meet a certain standard of rules and you'll comply with that. And essentially there will be fewer procedural difficulties throughout the process, and this will reduce the time taken and costs in resolving the dispute. Next will be whether an arbitration is local or an international arbitration. It is not a choice. The law of this parties cannot choose as to whether it is local or international. The law of the seat of arbitration will determine whether an arbitration is local or domestic or an international arbitration. And what the Arbitration Act says about this, the Malaysian Arbitration Act, is that a domestic arbitration means any arbitration which is not an international arbitration. So it is quite wide. Then it leads us to the question of what is an international arbitration. And an international arbitration is basically if a party's place of business and trading activity is situated in another country, or if the seat of arbitration is not in Malaysia, or if a substantial part of the obligations to be performed or the closest place connected to the subject matter of the dispute is situated outside the country, or if parties have expressly agreed that the subject matter relates to more than one country. Yeah, those are the requirements. And if either of them failed, then it is considered an international arbitration. Otherwise, an arbitration will be considered a domestic arbitration. Moving on to choosing the number of arbitrators for the purposes of your arbitration agreement. It is common for parties to select a sole arbitrator or a panel of 3. Parties are free to agree on the number of arbitrators, but it should not be an even number because this might cause a deadlock between the arbitrators. For example, if there's 4 and two agree with the claimant and 2 disagree, this would cause a deadlock and parties would have difficulty proceeding. So it should always be an odd number. And what are the considerations in selecting whether it should be a sole arbitrator or panel of 3 or more? One of the more important things is cost in terms of arbitrators' fees. Of course, if you choose more arbitrators, the fees will be higher. And another factor to consider is also the speed in which the award is written and the appointment process to constitute a tribunal. If there is a panel of 3, they may take longer to concur on certain points in writing the arbitration award, and this will delay the issuance of the final award. And similarly, the appointment process for a panel of 3 will be longer compared to the appointment of a sole arbitrator. Okay, so this is just an overview of the arbitration process. This is a flow chart of the whole process. Typically, it would take 16 to 24 months. That's 1.5 years to 2 years. This chart is just meant to provide a general idea of AIAC arbitration proceedings. The steps and flow would differ for different arbitral tribunals because it is not set in stone. The arbitrator is free to decide on how the arbitration proceeds. Okay. However, in an expedited arbitration, in accordance with the AIAC fast-track arbitration rules, the arbitrator still has the discretion to decide on how it proceeds, but it will conclude within 6 to 7 months from the date of commencement of the arbitration. Okay, so in an AIC arbitration, the claimant begins the process by sending a notice of arbitration and a commencement request. The notice of arbitration should include a brief description of the claimant's claims, the nature of dispute, the relief sought, and a proposal for the appointment of an arbitrator. And then the respondent would typically be required to respond within a specified time frame. And in the case of an AIC arbitration, this is 30 days. And the response to the notice of arbitration should contain all the respondent's defenses, any counterclaim or set off. And if the respondent fails to respond or is not able to agree on the appointment of the arbitral tribunal, the claimant may proceed with the appointment of the arbitral tribunal in accordance with the provisions of their arbitration agreement or arbitration clause. This may be a sole arbitrator or a panel of 3. And if it's a sole arbitrator, typically they will get the director of the AIAC to appoint the arbitrator. Once an arbitrator is appointed, that arbitrator's appointment can be challenged if there are justifiable doubts as to the arbitrator's impartiality or independence, or if the arbitrator does not possess the requisite qualifications on which the parties have agreed on in their arbitration clause. There's no set time frame for this procedure. It really depends on the complexity and how the arbitrator intends to deal with this. If there is no challenge to the appointment of an arbitrator or upon the conclusion of the challenge procedure, and if the arbitrator is able to proceed, parties will be required to make payment of a deposit for cost of arbitration, which would include the arbitrator's fees and the arbitral institution's fees. If the arbitrator is unable to proceed and the challenge succeeds, then parties will have to go through the appointment process again. Okay. And once payment of the deposit has been made, assuming the arbitrator proceeds, the arbitrator will proceed to hold a preliminary meeting to discuss the procedural timetable of the arbitration. And this is where the arbitrator sets a time frame to issue his award. And upon the conclusion of the preliminary meeting, the arbitrator will then issue a procedural order stating the procedural timetable for the arbitration. The timetable, again, is not uniform for all arbitrators, and it really depends on the facts of a particular dispute and how the arbitrator intends to deal with it. Typically, after this procedural order is issued, the arbitrator may require the parties to agree on the issues to be determined by the arbitral tribunal. And there may also be a discovery of documents exercise if parties require it of the arbitrator directs it. But again, this is not, there's no set timeline for this, and it's up to the arbitrator whether this is necessary or not. And if the parties request for it. And upon conclusion of the framing of issues and discovery of documents, if any, the pleading stage will begin. And then the claimant would issue a statement of claim. And this would typically be within 3 to 4 weeks from either the procedural order or the discovery of documents stage. And then the respondent would issue a statement of defense and counterclaim. And if there is a counterclaim and the claimant wishes to respond to it, the claimant would issue a statement of defense to counterclaim. The tribunal may also require further submissions to be made, and they also may fix the time frame for those submissions to be made accordingly. But typically after the statement of defense to counterclaim, the tribunal will then hold a hearing for presentation of evidence or oral submissions. And after that, if directed by the tribunals, parties will need to file written submission, post-hearing submissions. And then the arbitral tribunal will then contemplate on the issues raised and start drafting the arbitration award. And once the draft is ready, the arbitral tribunal will send it to the AIAC for technical review. And what it means is basically they review for consistency in the award and stuff like that. They do not rewrite the award. It's just to ensure that improve the quality of the arbitration award in terms of consistency and so on. And once that is finalized, the arbitral tribunal will issue the award to parties. And once the arbitration award is obtained, parties can proceed to enforce it as a judgment and recover money, whether it's by garnishee orders or by insolvency proceedings. Okay, and I think that concludes my session for today. I see that there are some questions. Let me try to answer them. Okay, I see there are quite a few questions. I will type my answers to you. If that is okay.
Shaun, I think you need to read it out because not everyone can read the questions or can see the question.
Okay, sure. So one of the first question is actually, what's the difference between a seat of arbitration and the governing law of an arbitration? The governing law would be the law used to interpret the contract and is applicable to the merits of the dispute. And the seat of arbitration is basically which arbitration law would apply, and the consequence of choosing a seat is basically which court would have supervisory powers over an arbitration. And this is obviously not an issue if it's a domestic arbitration where both will be the same. But in the context of an international arbitration, this is different because there are other considerations that you will need to look at. I hope that answers your question. Then there is another question from Sintu. If the law of the seat and the arbitration is institutional arbitration, are there conflicting rules between the two which will prevail? The law of the seat and the arbitration rules are separate. I did highlight it earlier. The law of the seat basically, again, is just which law would apply in governing the arbitration, which court would have supervisory powers over the arbitration, which court you go to enforce your award at the end. And essentially, the arbitration rules are just rules within the arbitration on how you should proceed in terms of the appointment of the arbitrator and so on. So it's actually two separate set of rules. Sorry, yeah, two different things. So it would not conflict. There's a question by Chia. While there is a schedule for arbitrators' fees, is there a similar schedule for fees for counsel for acting for parties? I think in terms of fees, there's no set schedule for counsel, and there is certainly a difference in fees for domestic and international arbitration because of the time that it would take to resolve the dispute, looking at the complexity of the matter as well. If it's an international arbitration, you would encounter issues which are more complex, I would imagine, in terms of enforcement and in terms of interpretation of the contract. So I think, typically for international arbitration, the fees are higher, but there's no set scale, and it really depends on what you're able to agree with your client. Okay, is there a time frame for appointment of arbitral tribunal after the response to the notice of arbitration? If yes, what happens if no party proceeds with the appointment after the expiry period? There is no set time frame, but the claimant can proceed to appoint. So assuming the arbitration clause says that it is a sole arbitrator, it would typically also specify that if parties cannot agree, you will go to the director of the EIAC to appoint an arbitrator. And if parties are unable to reach an agreement, the claimant is entitled to proceed to request the director of the EIAC to appoint an arbitrator. After the response to the notice of arbitration. Okay.
Shaun, can you stop sharing so that you can just answer the questions? Thanks.
Okay. Okay. The next question would be, when and how did you start dabbling in arbitration? I started perhaps, I think 8 years ago, after I concluded my bar professional training course in UK. I started taking exams regarding arbitration because I was interested to know more. But yeah, it's been, I think, 7, 8 years now. The next question. If the governing law is Malaysian law, does that mean that Malaysian Evidence Act will apply? I see your point there, but no, it typically will not apply in arbitration proceedings. It certainly applies to court proceedings, but not arbitration proceedings strictly. So that is why people add in additional rules of procedure for evidence, like the IBA guidelines. Yep. The next question. Are parties bound by what is stated in the notice of arbitration and response to notice when filing the pleadings later on? No, they are not. You can even insert the language in your notice of arbitration to say that these are your claims, but they're not exhaustive, and you reserve the right to add on to them later. Similarly, the respondent can do that for the response to the notice, and they can add on later. Okay, the next question, how long does an arbitration case typically last for? This is quite hard to say. Some might take 1 to 2 years. Some may take as long as 8 years. It depends on the complexity of the matter, the amount of documents involved. But like I said, if it's a fast-track arbitration, it would typically end within 7 months from the commencement date. 6 to 7 months from the commencement date. Okay. How long does okay. What is the legal consequence of deciding whether an arbitration is a domestic or international arbitration, particularly when there is no dispute as to the seat of arbitration or the substantive governing law? I think in this context, one of the consequences I can see is number one, the EIAC would categorize it differently. There's a different applicable fee to administer an international arbitration and domestic one. Yeah. It doesn't have much legal consequence, particularly when there's no dispute as to the seat or substantive governing law, actually. Yeah. It's just that it's categorized differently. The arbitrator that you appoint for international arbitration should be aware of international law and how to resolve the conflicts of law, if any. And I would think that that would be the main impact. Yeah. The next question, if the seat is in Malaysia, can the procedural law of other countries apply? If the seat is Malaysia, then the Malaysian courts would have supervisory power over the arbitration, and that would be the applicable procedural law. If you're talking about whether, if the seat is Malaysia, whether parties can choose a different governing law of the contract, then yes, you can. And the arbitrator will have to interpret the contract and decide on the merits of the dispute based on the governing law of the contract. Yeah. Okay. Why do you choose to be in arbitration? I thought it was interesting when I studied it in my alternative dispute resolution studies during the UK Bar. And it's also, it's different from court work because you can have international arbitrations and cross-border work. So I think for dispute resolution, that is quite rare. So I thought it would be a good idea to get into arbitration. And it's also very closely connected to construction because most construction contracts have an arbitration clause. So that is why I chose to be in arbitration. To what extent have parties have relief in court having gone through the arbitration process? There are many cases where parties apply for interim relief during the arbitration process. For example, an injunction, as I mentioned earlier. Having gone through the process, once the arbitration award is rendered, once the final award is rendered, parties are able to enforce it as a court judgment. And with that, they would typically go for garnishee proceedings or for winding up proceedings to get their money back. So it does happen quite often, and it is the usual way parties recover their monies. Any suggestions or tips if you want to enter arbitration? You can start looking at courses offered by the Chartered Institute of Arbitrators. They accredit arbitrators all around the world. So if you take their exam and you become a fellow of the Chartered Institute of Arbitrators, you can be impaneled as an arbitrator all around the world. Basically, I have taken the exam and I am a fellow of the Chartered Institute of Arbitrators, and I'm impaneled as an arbitrator in Malaysia and also in Thailand. Yeah. When must you start an arbitration, and is there a limitation period? I suppose if you are the claimant, you get to decide when you want to start an arbitration. Preferably, you prepare your case and ensure that it's very strong before you proceed. You wouldn't want to proceed without preparing your case and be caught not being prepared. The limitation period, the typical limitation period would apply to commence claims in court. And it is calculated from when you send in your commencement request. The next question is, can you share with us your experience when you first joined arbitration and how it helped me grow? When I was first involved in arbitration, like I mentioned earlier, I started studying it after my bar, and then eventually I got involved in construction disputes. How it has helped me grow as a lawyer, I would think it has given me the opportunity to look at different aspects of the law, which you wouldn't in typical court cases. Like there's always the conflict of law arguments, the issues if a seat is not decided, or if there are conflicting laws in an arbitration, because typically it involves 2 or 3 different type of laws. What happens in that situation? So I think in that sense, it's helped me grow. It's helped me understand international law better and the conflict of laws as well. The next question is arbitration bound by case law? If not, how is precedent referred to since awards unpublished like cases? A simple answer to that is no, arbitration is not bound by case law. But case law is certainly persuasive in assisting in supporting your arguments that you advance in the arbitration. So you put it in your pleadings to persuade the arbitrator to decide in your favor, but it does not bind the arbitrator per se. What is an arbitration award and what must it look like? An arbitration award doesn't have a specific form. It is essentially like a judgment, and it has certain criteria which you should meet. But there is no model arbitration award that you could refer to. Yeah. Will we get the slides later on? Yes, I understand that my colleagues will circulate the slides to you later on. Can we challenge an award? Yes, you can challenge an award. You can apply to set it aside, or you can apply for it to be, you can apply to refuse its recognition. But there are only certain grounds in which you can do that. For example, if it's against public policy, yes, and very limited grounds if it's against natural justice and stuff like that. Yeah. So you can challenge an award. The procedural law must follow the seat. Is the next question. The consequence of the seat is basically which arbitration act would apply and which court would have supervisory powers over the arbitration, where you go to enforce the award or where you go to set aside the award. So that is the consequence of the seat. I am not too sure what you mean by the procedural law must follow the seat. But yeah. If you could clarify your question, that would be good. The next question here is how different is arbitration practice in Malaysia and other countries, or is it the same? I think it is pretty much the same in Malaysia and in other countries. It's just that Malaysia is not often chosen as a seat for arbitration. I think people typically choose Singapore or Hong Kong because they have very favorable arbitration laws and they have very established arbitration institutions. But we are not far behind in terms of arbitration practice, in terms of the expertise and knowledge of our lawyers and arbitrators. It's just that parties prefer to go to Singapore or Hong Kong. If parties are Malaysian or incorporated in Malaysia, but the dispute concerns a project outside of Malaysia, is that a domestic or international arbitration? If the project is outside of Malaysia and a substantial part of the project will be performed outside of Malaysia, it will be considered an international arbitration based on the provisions of the Arbitration Act. Yeah. Between the Contracts Act and the Arbitration Act, which one prevails? These are two different things. The Contract Act will be related to the governing law of the contract, and the Arbitration Act would be related to the seat of the proceedings, and they are actually two separate acts for two different things. So I do not think that they would clash, because the Contract Act will be used for the purposes of deciding the merits of a dispute, and the Arbitration Act will basically just specify the court's powers in terms of intervening or assisting with arbitration. So I don't think there'll be a clash in which you would need to decide which one prevails. Can I share the steps on how to obtain these additional licenses for arbitration? I think you would have to have a look at the Chartered Institute of Arbitrators website. As I understand it, there are 3 modules which you need to take exams 4, and after completing all 3, you can apply to be a fellow, and with that, you can apply to be empaneled in arbitral institutions like the AIEC. Okay. How do you keep motivated and be passionate in law? Okay, this is not really related to the talk today, but I suppose you have to love the law to keep going. If you don't love it, then it'll be very hard for you to keep motivated and passionate about it. You have to like it. You have to try your best to be good at it. And I think when you're good at it, you'll be motivated and you'll be happy to do it. Can the claimant add a new party to arbitration midway after the commencement of arbitration process, or does the claimant need to commence fresh arbitration proceedings? Okay, this is a bit of a complex question. So parties can only go to arbitration if there is an arbitration agreement, as I mentioned at the very start. So if the new party is not a party to the contract or an arbitration agreement, it will be difficult to add that party into proceedings. But it is possible to add a new party to proceedings if that party agrees to be subject to arbitration, or if that party is a party to the arbitration agreement. The claimant does not need to start fresh proceedings in that situation. Are arbitration proceedings confidential in nature? Yes, that is one of the advantages of going to arbitration. It is confidential. The awards are not available like judgments to the public. The public cannot attend arbitration proceedings like you attend court proceedings. Like the public can go and view court proceedings. You can't do it for arbitration. And yes, so yes, it is confidential in nature. Why do parties usually opt for arbitration over courts? They opt for it because of a variety of factors, as I understand it. Before this, courts were not so efficient, but I understand that the courts are more efficient these days. But one of the reasons why parties chose arbitration was because it was quicker. Arbitrators tend to have specialist knowledge of subject matter. Yes. Yeah, they would typically be, for example, if there's a construction dispute, these arbitrators would be construction lawyers, or perhaps architects, engineers, and so on. So they will have specialist knowledge on the subject matter of dispute. And that is why parties would choose arbitration over courts. It's also confidential. Parties would, people would not know that arbitration proceedings have been commenced against you. So that will not affect your business reputation. That is also one of the other reasons. Yeah. What do you do if you do not have a model arbitration clause in your agreement? It's not an issue if you don't have a model arbitration clause in your agreement, as long as you have one. And if it is workable, I think you can proceed to arbitration and it's not an issue. or if you want to proceed to arbitration and you don't have an arbitration clause or agreement, you can enter into one now if both parties agree. Otherwise, you can't go to arbitration and your recourse will be in court. What is adjudication and how is it different to arbitration? Adjudication in the context of Malaysia is adjudication proceedings in accordance with the Construction Industry Payment and Adjudication Act 2012. And it is a right given by the Act for parties to proceed to adjudication and is only applicable to construction contracts for projects partly or wholly performed in Malaysia. So it is a shorter process compared to arbitration. It is meant to be a speedy process to facilitate timely payment in the construction industry. So it typically would take between 4 to 5 months to complete. The procedures for the determination of the dispute is not as extensive as arbitration because there's a short time frame in which the adjudicator must render his adjudication decision. And that is why adjudications are typically documents only, and you do not have a hearing, and you do not go through the evidence in that sense. There's no oral submissions and so on, unless the adjudicator requires it. But typically it doesn't happen because of the short time frame. Arbitration or adjudication is also temporary, and it still can be challenged again in arbitration, whereas arbitration is final, and the only way to challenge an arbitration award is to set it aside, and you can only set it aside under very limited grounds, like if there's a breach of natural justice, or if it's against public policy, or if the subject matter is not capable of being resolved by arbitration, or if the award was induced or affected by fraud or corruption. Yep, those are the limited grounds in which you can set aside an arbitration award. Yeah. So I think the main difference here would be just the length of proceedings and the subject matter. Arbitration is not limited to only the construction industry, although it is very common in construction. You can arbitrate all sorts of disputes, but adjudication is only available, or at least statutory adjudication, in accordance with the Construction Industry Payment and Adjudication Act, that is only available to people in the construction industry. Yeah. Okay, what would happen if there are two conflicting governing laws in two separate agreements? So typically you can only arbitrate, or the agreement to arbitrate is contained in only one contract. So there's typically no cross-contract arbitrations. So those will be, in my mind, two separate arbitrations. So the issue of two conflicting governing laws in two separate agreements would not arise. Yeah. What are some of the usual contested procedural issues that would arise? if the seat is not specified in your arbitration agreement, parties would typically want to resolve that and would not want to proceed further with the arbitration until that is determined. So that is one of the common things in arbitration, international arbitration at least. Parties also contest the appointment of an arbitrator quite often, especially if they are of the view that the arbitrator is not fit to arbitrate their dispute. They will try to challenge the arbitrator to get a new one. Yeah. Okay, I think those are all the questions. I hope this session was beneficial to all of you. And I think my colleagues will circulate the slides later, and hopefully it'll be helpful to you. Okay.
Thank you, Shaun.
Thank you.
All right. So I'm just going to give a few minutes for the participants to say anything they want to say or ask any questions, or else then we can just close and end it because it's almost the time already. Thank you.
Thank you.